Hello, I'm an attorney. My name is Cheryl McMullen. I've been an attorney for 18 years, practicing first with the Court of Appeals as a briefing attorney, then as a general practice attorney doing all kinds of things, litigation, bankruptcy, real estate, etc. Finally, 6.5 years ago, I became a solo practitioner and was able now to do what I liked. And I found that I'm very surprised that I liked working with older citizens a great deal. I enjoyed working with disability and dying and areas where people needed special help with personal planning. So I bring that perspective to our meeting today. I want to tell you that although I seem like the oddball speaker because I'm not a medical speaker, I'm not a dental speaker, I work with doctors and dentists and all sorts of healthcare practitioners in resolving problems that our elderly citizens have. In doing so, I've learned that we are able to bring different insights to each other because of different backgrounds. When we deal with a human being, we're not dealing with somebody who is all a medical problem or all a legal problem. That's why we need to care what another professional does. The person is not divided, their problems are not divided, and therefore we need a multidisciplinary solution. UT Health Science Center has focused on this a great deal. I know Dr. Michael Lichtenstein, who spoke to you earlier, am I correct? He didn't today. I know he was on the schedule. But anyways, he has been of great assistance to attorneys. He was setting up, with the assistance of other people, a clinic in which all perspectives were investigated. Now, let me give you an example of how other healthcare disciplines have assisted us. When I work with somebody who is disabled, one of our ethical obligations as attorneys is to make sure that person is assisted, for example, through a guardianship. Now, a guardianship is used in the probate court system if there are no less restrictive alternatives and the person is incapacitated by a legal definition. It's not the same as a medical definition, it's close. Let's take an example of an elderly lady who is roaming at night in her car looking for her deceased husband. Okay? This person could be taken in by the police and we could have a mental health commitment. But this person happened to have a very loving family, so they were going to try to work with it outside the involuntary psychiatric hospitalization method. We went to the probate court and said, we would like to have a temporary and then a permanent guardianship for this lady, and the judge said, where's your medical? And we said, that's part of the problem. She will not go to a medical doctor. She hasn't been in years. We can't get her tested. So the doctor said, why don't I appoint a guardian ad litem? A guardian ad litem is a person who is just appointed for that particular case, that particular incident, and is to report to the court the best interest of the person. So the guardian ad litem, who happens to be a nurse with practice, she's had geriatric training, she's had psychiatric training, goes out and works with the lady. Meanwhile, I also get the court to order a psych evaluation by a geriatric psychiatrist. Now, the geriatric psychiatrist goes out and gives the woman her Miranda warnings, namely anything you say can be used against you in a courtroom, and works with the woman, evaluates her. So then we have both the case manager nurse who's helping us evaluate what are her needs, and we have the psychiatrist who's been able to look at her. The case manager nurse is able to talk her into going to see a geriatric internal medicine doctor as a way of saying, okay, you don't want your son to be your guardian, let's battle it by getting the facts. You go to a doctor, you show the doctor that you're really okay. Well, she goes to the doctor, and it happens to be a doctor who is not only a geriatric internal medicine doctor, but is super at looking at mental capacity. I mean, he does the mini mental status exam, he does clocks, he does all sorts of things. Plus, as this particular doctor has educated those of us who are in the probate legal area, the elder law area, he's looking for things like B12 deficiencies. He's looking at bladder infections. He's looking at other causes other than mental illness or Alzheimer's or dementia. He's looking at other causes for this aberrant behavior that this particular lady is demonstrating, who, by the way, is also buying Canadian lottery tickets, if you know about some of the frauds that are perpetrated on the elderly. As a side note, if and when you find these, would you please let the San Antonio Bar Association Elder Law Subcommittee know? We have a subcommittee. That's our committee. Our subcommittee is on fraud and abuse. And one of the things we're sponsoring later in this year is we're trying to get the elderly people to become aware of the frauds that are perpetrated on them. We have to watch each other. We have to watch the elderly people in our life. There just isn't enough enforcement against some of these things. The Texas Attorney General, John Cornyn, has backed the Texas Young Lawyers in putting out 2 videotapes, one on advanced directives and another one on living trust scams. That's sales of living trusts when people don't need them. And they make a lot of money, and they give them a vinyl notebook, and it has nifty little tabs, but that's not appropriate for that client. So now, trying to return to my little scenario about this lady, what did we do next? Well, her son, who was trying to get the guardianship, is a good guy. And those of us who are honorable attorneys look for people who would be good guardians who care for the person that they're asking to be guardian of, not just the one who wants to take over for mama's money. And one of the best tests, it's like a Solomon dividing the baby test. When we get in one of these guardianship brouhahas and we have family members on both sides pulling or wishboning the elderly person for the wrong reason, is we take the temptation of the money away, we put it in the hands of a third party like a bank trustee, and then you'd be surprised how no one's interested in taking care of mama anymore. It's a Solomon type test that we use. All right, getting back to this particular case though, we're resolving it now using a multidisciplinary approach of the geriatric psychiatrist, the geriatric internal medicine. We are using a case manager, nurse with backgrounds in these areas. Now, we need to look to there is another area that's selected. The judge, once the judge allows us to file the temporary guardianship, because now she has a medical, appoints an attorney ad litem for the elderly person. Now, what's an attorney ad litem? That person is supposed to go out and talk to the elderly person or the incapacitated person and say, I'm your attorney. Do you want a guardianship? And the person says, no. So it's the job of that person, just it's like a criminal defense attorney, job of that person to defend and use all the methods under the law to make sure that person isn't put under guardianship. What happens for those of us who are working in this area is that those who are experienced attorney ad litems are interested in the best interest of the elderly person. Now, we find some others that are going to milk it for the best that they can, but we assemble fiduciaries, agents, trustees, and guardians, and we try to work things out. So when I'm working with the attorney ad litem, she's saying, I don't like the idea you had that psychiatric exam done before I jumped into the case. Well, now the legislature has passed, and I assume it will be signed before June 17th by the governor, a little law that will give a 4-day waiting period and allow the attorney ad litem to jump in and to battle the psych exam. I still think I would have gotten it. The behavior was dangerous enough to the lady that I think a judge listening to it would let me have a psychiatrist go out and visit her. But anyway, as it has turned out, the attorney ad litem, the guardian ad litem, the case manager, and to a lesser extent the doctors, who only played a partial role, have gotten together and designed something that will safeguard this particular lady without having a guardianship. Now for Bexar County, that's wonderful news because we have 7,000 of them. We have 2 probate judges. I was visiting one nursing home, and I had a conflicting guardianship. It was controverted. It was going to involve a bitter litigation, and the administrator of the nursing home said to me, you know, Cheryl, I have over 100 some odd elderly people in this nursing home, and most of them have some sort of dementia or incapacity. And then she looked at me with disdain, but I only have 3 guardianships. Well, that's because most of the time we're able to handle dementia and incapacity without using the guardianship route. But if we have a person who is incapacitated but belligerent and resists doing things that they need to do for themselves, then, or they tear up, they have powers of attorney for health care, or they have powers of attorney for property, and they tear them up, then we might have to go a guardianship route. If the person needs an operation and they say, no, I don't want it, and flailing around, we might have to have at least a temporary guardianship to appoint a guardian to give the doctor informed consent so they can go through the surgery. All right, the other danger area comes about not from the elderly person who's belligerent and fighting us, but from third parties who are fleecing the incapacitated person. Then we get a guardianship to protect the incapacitated person who is not able to fight off that third party. In this particular case, not only the attorney ad litem, but the elderly lady hired her own attorney, came up with lots of money for the other attorney. Fortunately, the other attorney is a tremendously ethical person and has worked with us. So we're going to achieve a compromise. I'm not just an attorney, I'm a mediator. I've been a mediator since 1988, 13 years, come September. And in mediation, just as in guardianship, we try to find a less restrictive alternative for an elderly person. What are we going to do? We have a care plan mapped out. We have the elderly person agreeing to the care plan. We have home health that's going to come in periodically as long as she's living next to one of her 3 children, so they can also watch out over her. We have health reports, with her permission, going to her 3 children, so they'll feel rest assured that mom's being well taken care of and they can spot dangers. We have a bank that's going to be a trustee for her for an irrevocable, usually they're revocable, usually you can change them, but an irrevocable management trust. She will get reports because she likes to look through her bank records, and her lifetime accountant will get reports. So you see, we looked at the whole scheme and we put together something that is going to preserve her dignity, maximize her autonomy, accord her respect, involve everybody in her life, because you know one of the things that happens to the elderly is start shutting off. They don't want to socialize, they want to lock themselves in their house, and also filtering out the predators. We're going to have her tell us what charities she likes, but all the solicitations are going to come through the bank trustee. So we have achieved a success, and we are just delighted, and this is the way we'd like things to go. We do it more often than not. And a geriatric psychiatrist, in one of the cases we mediated a combination limited guardianship and a trust agreement and a family settlement agreement, how everything was going to work, was magnificent. In this particular case, the elderly gentleman very much enjoyed the companionship of someone who was into exotic dancing, and his family was not as pleased with the influence. Anyways, this geriatric psychiatrist helped us because, yes, the gentleman was incapacitated, but we wanted to save his pride and give him as much autonomy as possible. Give him even a little spending account that he could use on his friend. Okay? And so we did that. Also, she liked to drive him to his medical appointments. We insisted, and she was part of the agreement, that she would have a higher level of insurance, and we would pay for it, you see, to protect him. So we also had a case manager, nurse person involved. But the geriatric psychiatrist was amazing. When she got on the stand, we needed her to say that he had enough incapacity to be put under a guardianship, and we got a third-party guardian, so his pride wouldn't be harmed by having his son as a guardian, you see. So we got the third party, and those volunteers, God bless them, we have very few of them in our community. Two of the best are in their 70s, mid-70s. So if you hear of anybody that wants to be a voluntary guardian for the Bexar County Probate Court System, let us know. But anyway, so we had him appointed. So the geriatric psychiatrist on the stand had to testify to enough incapacity for a limited guardianship that would allow this third-party neutral guardian to make decisions for health care, etc. And just enough capacity to allow him to sign off on this bank trust that was going to run things according to the family settlement agreement. Martha Leatherman, she did a beautiful job of skating through the shoals. So I have a lot of admiration. But what we look at in the court system is the guardian ad litem is supposed to consider the best interest of the person and report to the court, like a tattletale, the fly on the wall. And the attorney ad litem has the legal obligation to do what the client wants within reason. And this is the way we respect the rights of the incapacitated person, and we protect the best interest, and it's kind of like a harmony, and it's a tension, and we struggle at it all the time. Okay, now, today on in your little handout, you see there's a cover page that talks about, there are about 9 questions there. Now, if you wanted to answer all those, make a passing grade of about 70%. You could cheat by reading the 10th page of the last handout and Exhibit F. But I'm going to go through some of them with you by turning to, let's turn to the first page, Ethical Issues, Client Identity. This doesn't occur in the medical situation as often. You know who your patient is, but in our situation, we need to know who our client is. Is it the son that brings in the incapacitated mother? Is it the incapacitated mother? We have different ethical obligations depending upon who it is. So don't be surprised if you have an attorney that you're involved with and the attorney is having to do maybe not what's in the best interest, but do what his client is asking him to do and making the best arguments he can for that. I had, for example, represented a mother. She put her assets under a trust. Her son was trustee. This was when she had capacity. Later on, she's incapacitated. Her son comes to me and says, can I use most of mother's assets to make me a loan so I can buy some property? I said, I can't represent you. I represented your mom. I know, however, you are a good man and your mom would want you to be able to do that. He went to another attorney and he did that. But you see, from my ethical point of view, it would have been against his mother's interest to put so much of her assets in a real estate secured matter where it couldn't be generating. Well, he was going to pay her interest, but it was kind of a risky sort of investment, so that wasn't good. So we face the kind of thing all the time. Now, how do we work with our clients? On page 3, we talk about the way we figure out motives and goals. We meet separately with the elderly person if we can. I don't know how you doctors and dentists and other workers do, but I'm sure at least part of the time you want to see what the elderly person thinks and feels, or the incapacitated person, even if they're not elderly, apart from the family members. But you also, I'm sure, like to have the family members there because they will remember what you said. They will be able to encourage mom to be compliant with her meds, etc. So they can be part of your team. We have to also watch the interaction between mom, because this is going to be her framework of support. So we want to know, what's their motive? How are they working with her? We listen for the hidden agenda, and on page 5 I have a whole list of things that we have come into our office. Our society devalues age, so sometimes the elderly person is saying, I want to give my home to my son. I'm trying to figure out why. Is it because you think you're old and useless? Is it because you are in depression? Are you mentally incapacitated because of Alzheimer's or dementia? Are you figuring that this is the way to get your son to care about you? Are you going to look for a greedy child, and the greedy child may be pressuring the parent? You know, there's elder napping just as there's kidnapping. And I've had the elderly person taken away to a ranch, and the crossbars and a new lock put on, and the one child stays there, and then the other people don't. So they block contact with other people. We call Adult Protective Services, it has a different name. Adult Protective Services, as all governmental entities, is overworked and underfunded. They have different levels. Last time I talked to them, they had 4 levels. One, they have to see it within 24 hours, one 48 hours, one 2 weeks' time. Financial predators and their abuse don't get as much attention as the actual physical abuse. You know also that the emotional abuse on the elderly, the bad-mouthing and the threats. I remember my tough grandma who could handle any kind of business. And the men cleaned her yard. And it was a huge one, and they had to use equipment. They had told her $100. This was years ago. When they came to her door, they demanded $300. She paid them. I said, Grandma, why did you do that? Because they knew I lived alone, and they would be back. We have elderly, they don't have the mobility with the automobiles. Their health is at risk. They have to go to the pharmacy every 60 days because they don't give them, longer-term prescriptions. I know there's some mail orders, but there are lots and lots of dependencies involved. They don't walk as well, they don't see as well, they don't think as clearly. And if they're not surrounded by a good support network, we are in trouble. And we have nuclear families. We've enjoyed the freedom and the mobility of our culture, but as we enter our older years, we're going to have trouble with this. We have a lot of people who have parents in Texas, and they're in Massachusetts, etc., and they're calling around for resources to go out and evaluate and help mom. The elderly person may also be the victim of misinformation. My neighbor told me that I had to give away my house because the government will get it if I need to go into a nursing home. Now, there are predators in the area of selling Medicaid information that will take advantage of the elderly person's fear. They will charge them a percentage of their assets to teach them ways that a person can, under the law, qualify for Medicaid. And sometimes they make mistakes and sell them things that won't qualify them under the law. Whereas, if you go out into our legal community, you are going to find good elder law attorneys who will, for the price of a single-hour consultation, teach that elderly person and the family What are the rules of Medicaid? Do you qualify, don't you? And do you want to qualify? You also know that those of us who are in our middle years are being hit by more and more pitches for long-term care insurance. Jane Bryan Quint apparently came across with an editorial that we don't want the rich transferring their money and then the public has to pick up the tab for long-term care under Medicaid. One of the commentators in our, we have listserv groups where we talk to each other about things. One of the commentators noted that that same article was on a page that talked about tax dodges. So in other words, it's verboten to do any kind of planning within the law for Medicaid, but it is so chic to do the tax loophole planning under the income tax and estate tax law. You know that Granny goes to jail law in '97 was if Granny did any of these techniques and was disqualified, then she could serve jail time. And of course, ARP and the Great Panthers talked to their senators and congressmen. But what happened next is that, well, everybody hates lawyers, and we enjoy that very much. But what they did then was the lawyer goes to jail law, and it meant anybody who counseled either as a lawyer or as an advisor in any capacity for pay, and the advice led to the person being disqualified for Medicaid, and that person could suffer jail time fines. So we worked past that. Janet Reno said that was against the First Amendment, and she was right. All of us have the right to know what the law is. Then our clients have to search within their soul for their own integrity and decide which way they want to go. Do they want to choose the Medicaid route? Are they eligible within the law on the Medicaid route, and so on? But they don't have to pay exorbitant fees to find that out. Okay, now let's go to the skip to the last section, and you may have a color sheet. I kind of asked for it, but it's the one on medical directives, because these are the things you deal with most often. Okay, tools for incapacity, property tools. We use power of attorney for property, trusts, guardianships of the estate. There are community property management rules, which just as of this last legislature, if the governor lets it become law, makes it a lot tougher for the spouse to community manage. We have account card and agency or joint ownership designations. For example, mom puts the son who's in San Antonio on her bank account as an agent, not as an owner. If he puts mom puts him on as the owner, and there are other brothers and sisters, and the will says give it to everybody equally, that account card is going to dominate, and the son will be able, if he so chooses, to take away all the money. So it's very important that the elderly person choose a right bank. Many of the banks in San Antonio, especially the big ones, don't offer these agency accounts. Use a power of attorney or some other kind of arrangement that will allow, when you become incapacitated, to have this kind of protection. The next area is health care. Now, those of you who are in health care know that the best thing is the medical power of attorney for health care. It used to be called the durable power of attorney for health care. It's the same animal. It has a slightly different name. And the whole crux of it is the person appoints an agent to function and make healthcare choices and inform consent decisions if the person is incapacitated, if the person cannot communicate to the doctor her wishes. Now, I have clients, one of them called me from the emergency room and said, well, no, not the emergency room, the hospital, and said, Dad is ill, and it looks like he's going to go. What should I do? I know I have his health care power of attorney. And I said to her, can he wink or blink or crook his finger? Because I knew Dad over many years, and I knew he had a mind of his own, and if he could express himself at all, we should respect or honor what his decision was. Fortunately, he did, and he got better, and he's still going strong 3 or 4 years later. Now, if you look at the last chart, F, it gives you a summary of the directives that were amended or changed in the last legislative session. Not this one. This one, 2001, breathe a sigh of relief. They didn't do anything to the health care directives. They're fooling a little bit with the power of attorney, but not the form. They tried to wholesale fool with the power of attorney for property, but it was defeated in the last hours of May 23rd. Panic, okay? But we do have directives to physicians that were changed, excuse me, in the 1999 legislature. The directive to physicians, major change, 1990 change, major. Okay, now, how were they changed? It was changed in two ways. It's longer. It's not that little one-page baby anymore. And it deals not only with terminal illness, it also deals with irreversible conditions. The form defines what they are. If you want, I've given you the forms. Exhibit A is the directive. And you see there, oh, it's hard for you because you don't have tabs, but it asks, if in the judgment of my doctor I'm suffering from a terminal condition which I'm expected to die from within 6 months, even with available life-sustaining treatment, what do you want? Number one is I request all treatments other than those for comfort care be discontinued, not be started, okay? Number two, no, I want life support, even if I am terminal. I had a gentleman come into my office years ago when we didn't get to have a form that said this kind of thing. We only had the old form that said terminal illness, I want removal of life support. And the statute is pretty lenient. If you have people around you, it can be given by your surrogate, and it can be given orally. So what if this person became comatose and the proper persons in the family under the old directed to physicians law said, you know, terminate life support? That would not be what the gentleman wanted. He came in with his nurse, he had oxygen, he was in a wheelchair, and I was doing his documents for him. His will, his power of attorney for property, his medical directives. And he said to me, I want to be, I've come back from the dead 3 times on the operating table. I want to continue to fight for life. Okay, what I did at that time was I created a document that told everybody that's what he wanted. So no automatic procedure would kick in for him. This new legislation is a product in 1999 of a combination of input of about 30 different organizations. The committee that was listening to proponents and well, they turned out all to be proponents. It started with pro-life people, it had Hemlock Society people, everybody in those 30 groups liked it. Now lawyers don't, and I'm still battling for it because I give speeches to lawyers all the time and I'm trying to figure out why they don't. And last night on the listserv they were saying, well, you know, I feel uncomfortable because I don't know what an irreversible condition is despite its definition, etc. Well, what I do, ladies and gentlemen, is I put a section in here on page 2 of your Exhibit A. You see it's all in dark and it's underlined. That means it's mine. It's not part of the statute. And what I say is, my client is signing this and saying whether they want comfort care, life support to help their agents out, but we still want the agent to make the final decision. Here's why. The agent is supposed to not do what they think is in the best interest. The agent is supposed to do what they think the person wants according to their value system, their belief system. Okay? Now, we know that somebody may sign that document in my office today, and 5 years from now, when they have Alzheimer's, they may have said, life support, no way. I just want comfort care. I want palliative care. Okay, you go to the end of the line, 5 years from now, we've got a cure for Alzheimer's. This stays in. If they haven't given their agent predominance and a doctor comes across this, they're going to say, oh, that person just wants whatever, okay? Now, it's true that if it's not irreversible anymore, that probably it won't fall into that category. But still, I want somebody who can listen to the doctors, listen to the other healthcare providers, keep up with the data, and keep up with the changing feelings of the principal person, the person who signs the documents, in making that final decision. So all my documents, even though the law says whatever you execute last controls, all my documents say the agent controls. My last executed medical power of attorney or proxy selection controls. Okay? Now, other things, out of hospital do not resuscitate order. How many of you are familiar with that? Wonderful. I spoke to a group of about 60 middle-aged people. That would be Exhibit B, if you'd like to look at the version. It took them about 8 months to come up with the fine print. And it's really a two-sided document if you order it from the state or if you pull it off of online. It's supposed to be a two-sided document. And you feel for the Texas Department of Health, because why did they do all this fine print? Well, the law, the statute, told them everything they had to put in the form. Didn't tell them how they were possibly going to cram it all in, but they told them what would be put in the form. The big change in this document in the 1999 legislature is it's no longer just terminally ill people. Anybody can select ahead of time that when EMS pulls up, they want EMS to help them out with comfort care, but they do not want the transcutaneous pacing, the cardiac resuscitation. Why would a person feel that way? Well, could be a lot of reasons. The doctor does need to sign, but in the old days he was signing this form verifying that the person was terminal and therefore had the right to refuse these various EMS procedures. Now the doctor just signs it. Why did they leave the doctor's signature on there? I don't know. I don't know. But in that audience of 60 elderly people, and I was talking about estate planning, I was talking about Medicaid, I was talking about guardianships, I was talking about these change directive forms. I had 16 questions. 12 of them were, that do not resuscitate order, how can I get a hold of it? Now, my fellow attorneys who on the internet last night were saying they don't want to get into this mess of this advanced directives, they even use the older form. I'm telling them that our older clients want this kind of stuff more than they want a will that says what happens to the ranch and the silver after they go. They are deadly afraid of periods of incapacity. They are afraid of being hooked up, and therefore they need people to talk to them about this. It may be their doctor. Therefore, I'm glad doctors need to sign off on this. I don't want this form overused. You may have lung cancer, and your doctor may say you only have 3 more months to live, though a lot of doctors do not like to give those time predictions. They give, a range. But suppose they do. Go to Luby's and choke on a piece of fish. You don't want EMS to help you out? Maybe you still have a few things to do with those last couple of months of your life. You want to get things in order. You want to patch up family relationships. Life, even when it's when we're young, we kind of think that, we don't want to live if we can't have a quality of life. I'm saying, don't give me that. What does quality of life mean to you? One of my clients who was in fact dying of lung cancer said, I'll tell you what it means. It means a day I can't go out on the golf course. Well, he already couldn't go out on the golf course, okay? But to an elderly person, maybe you need to go around with a walker. Maybe you need to have the oxygen tank. Maybe you have ALS, like one of my friends has right now, worked at Kelly. She has the stomach tube. She can't move anything but a little bit of her left hand. She can't even use the fancy wheelchair that it took them so many months to finally get for her. But there is still some quality of life there if you value it by a different value system than you are a child of Madison Avenue and can keep the economy running. you're in the proper demographic group. The quality of life may mean simply that you can, even though you can't speak, indicate some kind of love to the person in your family who's caring for you, namely her mid-70s mom. It could also be even a one-way situation where you have a person in a coma and you have the family taking care of lovingly for 10 years is one of the situations I knew of. There is worth or value, depending upon your system, maybe in some of that. But on the other hand, I want to say that those of you who are doctors, those of you who are attorneys, those of you healthcare providers, we also want to advocate for the person who wants to choose not to go through chemo, not to do the radiation. One of my clients came to me and said, I'm filling out this form, but I want to know what the clergyman, who is also a medical ethicist, thinks about it, but I tell you how I feel. I want to go to God. I don't want, and she was already have various advanced and painful health conditions. She said, I just want palliative care. I'm checking number 1 here on the terminal side, flipping page 2 at the top of the form, checking comfort care in the irreversible condition side. Got a call a couple of months later. The phone messages said she was in the hospital, she was going in for testing, she needed to hear from me right away, and I finally got a hold of her and I said, what is it? And she said, you know that directed to physicians, I have to change it because the medical ethicist, theologian, whatever, said to her, choose life. At which point she had put me on as 4th agent because I believed I could comply with her wishes. I had read up on what her religious views were, and I had read some material from the church she belonged to had published position papers on it. And I said, I don't agree that that's what your church would dictate. Are you sure? And she said, yes, yes. And I said, all right, I'll send you a fresh form, but I do have to take myself off as number 4. When you come out of this crisis, we'll talk at greater length. Well, I sent the form to her. Never heard back from her except a pastor in the courthouse the other day, and she said, by the way, Cheryl, you were right. Now, I don't know what I was right about. Was I right in saying that her church would allow her to make her own decision? Now, I have read some religious expressions on this, and they say there's a presumption in favor of artificial nutrition and hydration. A presumption. Now, in law, we as lawyers say, is it rebuttable? Can I disagree with that? The reason why the body of this particular church took that position, they explain in their paper, is they want people not to be unduly hastened toward their death. A client of mine's mother was taken to the nursing room, and he took her in, and she was choking on a vitamin pill, but it was not in her air passageway. It was somewhere higher up, and she couldn't swallow, etc., but it passed as the calcium pill. It was caught between the flap and the trachea, the epiglottis, and it kept hammering and kept making a clicking sound, click, 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 and then the salivation. And so 5 hours in the emergency room, and eventually, thank God, the calcium dissolved, according to my client. But you know what's interesting is that they waited, he said they waited about an hour to finally IV the blood pressure medication to bring it down from 250 over whatever. But they did not wait a minute to ask, do you have advanced directives in place, and how do you feel about life support or whatever. So I was interested in that story. Also, that son had been excluded from the ER room until he slipped past the maid who knew the code. But anyways, the input of the family, I think, is pretty important in that. And he told me that eventually the head of the ER room admitted that to him, that yes, he should have been allowed in. But I'm forgetting, because that story is so interesting. I think the tendency may be to really advance these advanced directives maybe sooner than the person desires. So maybe that religious group that decided to have a presumption in favor of artificial nutrition hydration isn't such a bad idea on a general policy basis. Now, on the individual basis, it's a benefit burden analysis, and it can mean, do you consider the benefit of being able to extend your life or whatever the doctor told you, in whatever condition the doctor suggested to you or your fellow patients told you might have, versus the pain of going through the procedure, the expense to your family, the burden and heartache on your family? You see, there's a lot of things to consider, and that decision is sacred. And hopefully they've executed agency appointments, medical durable power of attorney, okay? So their agents can help them. And I have my people do an additional thing, medical authorization, a new document. I made it up. It's in here. It's number E. And why I did that is because you want the help of your agents and you want your doctor to be able to get past the privacy rules and the fear of liability to talk to you, the agent, before your aunt becomes so incapacitated that the medical power of attorney kicks in. My personal philosophy. Now, if people, let's see if you can answer your questions. I sometimes talk at a banker's trust school, and one of the things they require me to do is not only give a little speech, but do test questions. So, number one, family members are presenting you, the doctor or the nurse or whatever, with conflicting written medical directives. Which do you follow? The last executed, unless they have extra language in like I do. What if one person's a guardian of the person as a court order saying they get to make medical decisions, and another person is an agent under a medical power of attorney? Not an easy answer. You can read it on page 10, but the attorney getting the guardianship should say what happens to that medical power of attorney. All right? Should say if the medical power of attorney is killed. You know paper, scissors, rock? Okay. You've got the rock of a durable power of attorney for medical care appointing an agent. Does the guardianship paper cover the rock? It depends what the guardianship order says. And preferably this does not happen to you at 5:05 Friday afternoon when you can't find a probate judge. Okay. What can guardians authorize? People
You didn't answer the question.
Well, the answer is you're stuck. And you hope you, because the guardianship order, I think if I were going to make a guess, I'd probably follow the guardianship order if it said medical stuff. But what an ideal guardianship order should say, the medical agency is killed by this power of attorney, by this guardianship. You see? But what if it doesn't? And what if you're in a situation where you have an absolute dire emergency? Will you talk to your attorney? So I shouldn't be giving you legal advice. But if you call me, I'd measure it all, and I'd probably play the mediator and say, can you get the two to go along? Can we go to the ethics committee of the hospital? Can we, because we can't get a judge. Or we try to find the home phone number of the probate judge, and we try to get a change in the order. Some of these things there aren't answers to. Don't shake your head. There are all kinds of ways out. All you need is a good mediator. No. What I'm asking, but they should have said, shouldn't they? They should have said in that guardianship order. But remember, not all medical professionals are at the top of their game.
Well, I mean, all it's telling me is that I need to get my ducks in order long beforehand.
And so do your patients, which, God love it, thanks for the federal law that says before you go into the hospital, you need to do that. Okay? Now, I think my time is just about up, but I am going to stay during the lunchtime, so if any of you have any questions. Also, I'd like to know some of your experiences with these directives to physicians, because based on what's going across the internet with these attorneys in the last couple of days, I speak to them again in August and also at a UT School of Law seminar in Galveston late August, and I want to be able to carry what some doctors think about some of these babies. I mean, y'all want the direction. Y'all want the direction. And we want to give it, because there's a case out there that I won't go into, but Hugh Finn, and it was in Virginia, where the governor of the state was battling the wife and the parish priest on one side and the bishop on another side of whether or not she was starving the poor man to death and whether she was culpable. I mean, this can become litigation. It hasn't in Texas. We have too much sense. But I'm not going to guarantee we will always have too much sense. Okay, all right. Now, you're not supposed to make those comments without having the microphone in your hand. I guess I will conclude this, and I'll thank you for your attention, and I am available later for questions.
He must know something, but don't say nothing. He just